We might have to save it. You all got
If everyone could be seated, please, we will begin. So welcome back from the break. And for our final panel, we will be discussing forfeiting Russia's assets through an international compensation mechanism. And our distinguished panel will be chaired by the Ambassador of Canada to Ukraine, who's traveled all the way from Kiev to participate in this gathering, Ambassador Natalka Cmoc. So the floor is yours. There you are.
All right. Well, good afternoon, everyone. So I have the additional challenge to try to inject some energy into the room, being the last panel here. And we're going to try to do a slightly different format, hoping to be a little bit more interactive and trying to make sure that we have time for questions from the floor or from our online audience as well. So it's an immense pleasure to be moderating this panel on a very critical topic that I often get asked in Ukraine as the new ambassador there. So I'm hoping that I will learn a lot today so that I'm able to answer a lot of those very important questions. So we do have a significant expert panel here today of 6 experts that many of whom have already presented on this topic in the past. So today we will likely see sort of an advancement and evolution of their thinking collectively as well as individually. So looking forward to that. Today marks the 635th day in Russia's full-scale invasion of Ukraine, which has brought untold death and destruction and a huge cost to communities, Ukraine, and the world. More than ever, the unjustified war waged by Russia, its full-scale invasion targeting cities, destruction of critical infrastructure, and the killing of thousands, must not be ignored. So while forfeiting Russian assets comes with many complexities and challenges that we'll hear about today, it is a key component of delivering compensation, justice, and accountability to victims of Russia's war. And it carries important implications not only for Ukraine, but also for the ways in which the world thinks about accountability going forward. So this is not a small challenge. Ukraine and its partners must tackle what is now estimated at, and this is a conservative figure, of $400 billion in recovery needs. And this does not account for the thousands of innocent lives and lost families torn apart. Canada is considered a leader in this area and remains committed to working with Ukraine and its partners to hold Russia accountable for its illegal invasion of Ukraine and the atrocities being committed. So the format, as I mentioned, I'm going to introduce the panelists, and then we've all agreed that we're going to have 3 main topics, estimating about 15 minutes each, where a few of the panelists will provide the leading context, lay out sort of the groundwork, and then open up the floor between them first. And then after the 3rd question, if time remains, we would love to open up to the audience as well. So, the panelists. First, I'd like to present Iryna Mudra, Deputy Minister of Justice of Ukraine. Iryna Mudra has been serving as the Deputy Minister of Justice of Ukraine since 2022. Previously, she was the Director of Compliance Control and Supervision of Compliance Regulatory Requirements Department, Deputy Director of the Debt Restructuring and Collection Department, and head of the legal team which accompanied the lawsuit against Russia for damages caused by the illegal annexation of Crimea. She studied law at the Ivano-Frankivsk National University of Lviv and completed an MBA diploma at Kyiv School of Economics. Second, we have Mr. Allan Rock, former Canadian Ambassador to the UN, former Minister of Justice and Attorney General of Canada. The Honourable Allan Rock is a member of the World Refugee and Migration Council. He has been President of the University of Ottawa, Canadian Ambassador to the United Nations, a member of the Federal Cabinet, including as Minister of Justice and Attorney General of Canada, and a Toronto trial lawyer. Third, we have Professor Robert Currie, a Professor of Law and Distinguished Research Professor of Schulich School of Law, Dalhousie University. He is Distinguished Research Professor at the law, and his teaching areas include transnational, international, Canadian criminal law, public international law, procedure, and advocacy. His scholarly work focuses on crime that crosses borders and the laws that seek to regulate it, and his scholarship has been cited by numerous courts, including the Supreme Court of Canada. Professor Currie is a qualified barrister and has appeared at all levels of court in Nova Scotia and the federal court. Senator Ratna Omidvar is an independent senator from Ontario. She is internationally recognized voice on migration, diversity, and inclusion. In 2016, Senator Omidvar was appointed to the Senate of Canada as an independent senator representing Ontario. Senator Omidvar is the chair of the Senate's Social Affairs, Health and Technology Committee and the vice president of the Canada-Germany Inter-Parliamentary Group. Professor Philip Zelikow, White Burkitt Millet Professor of History at the University of Virginia and former counselor of the U.S. Department of State and deputy to the U.S. State of Secretary Condoleezza Rice. Philip Zelikow, Senior Fellow at Stanford University Hoover Institution, is a historian and former diplomat who has served in 5 U.S. administration and has written extensively on Ukraine war and possible use of Russian state assets. For 25 years, he held and chaired professorship in history at the University of Virginia, and for 7 years before that, he is an associate professor at Harvard University. He also directed 3 successful and bipartisan national commissions, the Carter-Ford Commission on Federal Election Reform, the 9/11 Commission, and the COVID Crisis Group. And last but not least, are the Honourable Lloyd Axworthy, who's joined us online. He's chair of World Refugee and Migration Council. The Honourable Lloyd Axworthy is the chair of the World Refugees and Migration Council and one of Canada's leading voices on global migration and refugee protection. After a 27-year political career where he served as Canada's Minister of Foreign Affairs and Minister of Employment and Immigration, among other postings, Mr. Axworthy has continued to work extensively on human security, refugee protection, and human rights in Canada and abroad. And with that, we shall begin. So, our first question, the first question will really talk and focus on the need. The second question will be sort of on the legal, political, economic implication and the mechanism. And the third question will be sort of the broader global strategic significance. So on the first question, I will ask Deputy Minister Mudra and Mr. Rock to set the stage by outlining the needs of Ukraine and how a compensation mechanism addresses those needs. Please.
Thank you, Ambassador. It's a great honor for me to be here today among such distinguished and esteemed panelists. But first of all, on behalf of Ukrainian government, let me express our gratitude to Massey College, Raoul Wallenberg Center for Human Rights, and of course, the Embassy of Ukraine in Canada, Prosecutor General Office of Ukraine for organizing such an important discussion on ensuring comprehensive accountability for crimes against children, for violations of international order and restoration of justice. Starting from 24th of February 2022, Ukraine is facing its most serious challenges since achieving independence in 1991. The war of aggression, illegally unleashed by Russian Federation, is already resulted in significant loss of life, unprecedented damage and losses, displacement of people, devastating destruction of civil infrastructure, And all this does not take into account the horrible consequences of war crimes committed on our land by Russian military. So just look at these figures. More than 110,000 war crimes have been registered by law enforcement bodies in Ukraine. 11,500 civilians died or killed, including 510 children. Over 19,500 children were forcibly displaced and disappeared. And you have heard today that there might be hundreds of thousands of children who were deported to Russia. 252 registered facts of sexual violence, including 13 against children. More than 167,000 objects of civilian infrastructure destroyed or damaged. Kiev School of Economics has estimated the cost of damage just to infrastructure, which amounted to $150 billion. And this does not include the damage and loss done cost to business, environment, land resources. The value of this estimation will increase by an order of magnitude. In March 2023, the World Bank estimated the needs for recovery for Ukraine to the amount of $411 billion. And this is where the estimation of our government meet this figure as well. So we do need more than $150 billion for recovery and reconstruction of infrastructure, more than $70 billion for the reconstruction of production sector, and this does not include housing, energy, social protection, agriculture, commerce and industry, healthcare, education. The total damage to land amounts to $10 billion. And only the undermining of Kakhovka hydroelectric power station was estimated to the damages was estimated to $14 billion, where 11 billion it's the direct the damages and $2.8 billion it's direct losses. So we can see these figures, and these are this is the need for Ukraine, and it does not take into account the damages, loss, injury, suffering caused to people, to ordinary people, to victims, to businesses, both private and public. We can easily double this figure. So about $1 trillion will be needed to cover all the reconstruction needs, as well as to pay compensation to victims of this war. And for more than 1.5 years, the governments are strongly condemning Russian aggression and united in actions to hold the aggressor state accountable and to restore justice. But this is not enough, because Russia's conduct is a serious breach of peremptory norms of international law, owed to all states. All states are entitled to address it, including by ensuring that Russia satisfies its duty to make reparations. So it does not depend on the consent of Russia. The obligation to make reparation already exists, and the states have to find the way how to induce Russia to comply with its international duty to make reparations. And Ukraine proposed the compensation mechanism, international compensation mechanism, in order to make Russia make reparations. The compensation mechanism comprises of three components: the International Register of Damage, which will serve as a database for all information on damage, loss, and injury, including the evidences on this damage, which will be registered, which will be transferred to this register, and this will be the basis for the future adjudication mechanism, adjudicative commission, which will determine the amount of compensation due to each victim, to the state, because the state is also the victim of this aggression. So the second component is the claims commission or compensation commission. But those two, components or tools are not meaningful if there is no source of paying out the decisions of the claims commission. That's why the third integral part of the compensation mechanism is compensation funds. The ultimate goal of our government and of our people is to get money, to get compensation, fair compensation to people, and compensation to the state for the recovery needs. And on November 14th, 2022, the United Nations General Assembly supported this concept of international compensation mechanism, where 94 states voted for the resolution on remedy and reparations for aggression against Ukraine. And the resolution recognizes that the Russian Federation must bear legal consequences of all of its international wrongful acts, including making reparations. The resolution also recognizes the need to establish the international mechanism for reparation and recommended the member states to create the International Register of Damage. For this year, so a few days ago, it was we celebrated the anniversary of this resolution, 1 year anniversary, and I am happy to say that Ukraine, together with our partners, has significant progress in implementing this resolution, because we already have the Register of Damage. This is the first step. It's been established by the Enlarged Partial Agreement on the Council of Europe umbrella, and it is hosted by the Netherlands in The Hague. And this register will serve as a record in the documentary form of evidence and claims, information on damage, loss, and injury caused on or after 24th of February 2022 in the territory of Ukraine as the result of Russian aggression, of Russian wrongful acts in or against Ukraine. So to date, we have 43 members of this register, plus European Union as the organization. So all in all, 44 participants of this enlarged partial agreement. The register, the international register, is called upon to receive and process information on claims of damages and evidences, categorize, classify, and organize such claims, assess and determine the eligibility of claims for inclusion into the register, and record the eligible claims for the purposes of their future examination and adjudication. This evidence database will be further used by future adjudication process by the International Claims Commission, as the register itself will not have an adjudicatory function. And as I mentioned before, the international compensation mechanism is composed of three interrelated elements. Establishment of the register is not the ultimate goal of our government. We will need the administrative body, the fact-funding body, which will be able to determine the exact amount of compensation. Under the enlarged partial agreement, international community agreed to to continue working in cooperation with Ukraine and relevant international organizations and bodies towards the establishment by a separate international instrument of a future international compensation mechanism. So we also understand that even perfect register of damage and the claims commission will remain with the decisions on paper if we do not have the source for monetizing these decisions. And Ukraine is confident that the main source for financing the compensation fund is the blocked and frozen assets of Russian Federation and Russian sanctioned individuals. So immediately after Russia started this war, the States has frozen the quite big amount of Russian sovereign assets. Of course, they won't be enough for to recover all the needs, recovery needs, but this is much of them. And Ukraine urges and continue to urge the states to invoke full state countermeasures to induce Russia to comply with its obligation to make reparations. It is time to move from sanctions to other more effective measures.
Thank you. Mr. Rock, as former Minister of Justice and Attorney General, as well as former Ambassador of Canada, you've seen efforts to address international crisis. Based on this experience, perhaps you could sketch out the current legal context and provide an overview of the current debate surrounding asset forfeiture and state immunity.
Thank you, Ambassador. May I say, in addition to the rather comprehensive list that the Deputy Minister just gave of damage to Ukraine and the basis for reparations eventually from Russia, we must also bear in mind that the government of Ukraine has been severely challenged by an economy that's badly damaged by the war. Sources of revenue that are no longer dependable. It has payrolls it must meet. It has the needs of its population that must be addressed. So when we speak about confiscation and repurposing of Russian state assets, it's not just on the Never Never plan for the reparation and rebuilding of Ukraine after the conflict ends. It's also to meet urgent current needs. And that's why this conversation, I think, is not about something that ought to happen in the future. It's about steps we ought to be taking today. Let me just give you a couple of words of background and explain why a member of the World Refugee and Migration Council is here talking about repurposing frozen assets. When Lloyd Axworthy, as chair of the council, began the work of the council in 2017, we spent time looking at situations around the world where there were large numbers of refugees, significant displacement. And we found that services for refugees or internally displaced persons are chronically and drastically underfunded. UNHCR is funded by voluntary contributions. There's no compulsory assessment as there should be. And so one of the recommendations we made back in 2019 in our first report is that countries like Canada should not only freeze assets of kleptocrats, corrupt foreign leaders who steal from their treasury and put the money offshore. We should not only freeze it, we should confiscate it and repurpose it for the benefit of refugees. So the people like Maduro and Gaddafi, these crooks who've stolen money and put it offshore and created refugees in the process, would see that stolen money put to use for the benefit of the displaced. We presented that idea to the government of Canada, and frankly, it was met with a rather tepid response. Right, Ratna? Then Russia invaded Ukraine. And there was a lot of interest suddenly in the idea of not only freezing, but confiscating and repurposing assets for the benefit of Ukraine. And I think it's important to give enormous credit to the government of Canada, particularly the Prime Minister and the Deputy Prime Minister, Chrystia Freeland, for leading the world in introducing in our Parliament legislation that does just that. Rob and I and others have written a paper about this called Leading by Example. And that's what Canada has done. It has led by example by adopting this legislation. And now I think our task is to advocate with governments everywhere to do exactly the same so that we can provide the kind of assistance, financial assistance that Ukraine needs today and provide for the reconstruction and compensation arising from the damage done by Russia in the unlawful and brutal war. Let me just state briefly what the Canadian legislation does. Adopted by Parliament in June of 2022, the legislation applies in specific circumstances, including the following: where there's been a grave breach of international peace and security, where there's been a gross violation of human rights in a foreign state, where there have been acts of significant corruption involving nationals of a foreign state. And in any of those circumstances, what can the government of Canada do under the legislation? It can seize or restrain property of foreign nationals or of a foreign state. It can seek a court order providing for the forfeiture of the property to Canada. It can pay out the proceeds of the confiscated assets. Pay them out either to restore international peace and security, to compensate victims of human rights abuses, of breaches of international peace and security, or significant acts of corruption. Now, nowhere in the legislation is there reference to Russia or Ukraine. This is a piece of legislation adopted for general application in this troubled world. The point I'd like to speak to this afternoon is with respect to the validity of that legislation in relation to Canadian domestic law, and my friend Rob Currie will speak to the international law dimension. Looking at the legislation from the point of view of Canadian law, the first question is whether it's consistent with our Charter of Rights and Freedoms. Among other things, Article 8 of the Charter prohibits unreasonable search and seizure. So the question arises, confiscating and repurposing, is that consistent with that charter right? The cases have been clear in holding that so long as there is some mechanism which provides for independent and impartial evaluation of the merits of the taking, then the seizure will not be unreasonable. And of course, this legislation refers to and provides for a court order. That, along with the very specific description of the grounds on which the government can move, the tests that must be met, we believe satisfies any reasonable expectation under the Charter with respect to the rights of those whose assets are taken. Second question under domestic law is whether such action can be taken in light of the bilateral investment treaty which subsists between Canada and Russia. The bilateral treaty, for example, prohibits the expropriation of an investor's assets. How might that figure in this conversation? Well, we believe that there are conclusive answers to any objection that Russia might raise with respect to the bilateral investment treaty. First of all, we observe that there's a real question whether the state assets on deposit in Canada constitute investments under the terms of the treaty. Investors, as contemplated by the parties when that treaty was negotiated, were more in the realm of business or private interests and not state assets. Second, we believe there's scope for challenging whether the taking under this statute would be an expropriation. Indeed, we believe it would not be. And if you look at the judicial interpretation of expropriation under investment and trade treaties, this does not fall within that category. Secondly, and more broadly, there's a real question whether Russia is in a position to complain under the BIT if we were to take and repurpose the assets. It's a question of clean hands. Russia itself has nationalized and expropriated foreign assets within its own state. It has also damaged and refused the return of assets in Ukraine owned by foreign interests, damaged and restrained as a result of Russia's act of aggression. And finally, the scope for interpreting the taking of Russian assets as a countermeasure in service of interests in international law which are more important and pressing than the bilateral interests protected by the treaty. So we believe the BIT can be dealt with and is not an impediment to Canada acting. Let me come to the last issue, which is state immunity. Canada, like many other countries, has adopted legislation providing for the sovereign immunity of other states. It's a codification of customary international law. Traditionally, countries recognize that their own domestic courts should not sit in judgment over the interests of a foreign sovereign state. That prohibition was codified in Canada by the State Immunity Act, and there are those who raise the question whether the taking of Russian assets and repurposing is inconsistent with the State Immunity Act, which expressly provides that the courts of Canada will have no jurisdiction, that the assets of a foreign state are immune from the jurisdiction of Canadian courts. To that, I offer three responses. First of all, it's open to the government of Canada to characterize the taking of Russian state assets as an executive action, not a court action. And therefore, the principle to which I referred does not arise. So that might sound cute, but it is a respectable and strong legal answer to those who have concerns about the application of the State Immunity Act. If the taking is by executive action, then we're not subjecting a foreign state to the jurisdiction of Canadian courts. We're acting outside the jurisdiction of the court. Second, there's the doctrine of countermeasures, which Rob will develop more specifically, but very simply stated, if a member state of the United Nations is in gross violation of international law, then they're in no position to complain about the actions of another state taken in response to that until they remedy their violation of international law. There cannot be a clearer example of the violation of international law than Russia's unlawful invasion of Ukraine. And so long as it is in violation of international law, it will not be heard to complain if Canada confiscates its state assets. And finally, I observed that Senator Omidvar, who has in the past introduced helpful legislation in the Senate as a private member's bill in this area, has also introduced an amendment which will change the State Immunity Act of Canada to make it clear it does not apply to Russia in these circumstances. So there'll be a legislative amendment if her bill is adopted by the Senate and then the House, which exempts the application of the Immunity Act in the case of Russia's assets. So I say from a point of view of domestic law, and of course I'm overgeneralizing for the sake of time, there's no charter issue. We have valid and strong responses to any complaint under the Bilateral Investment Treaty, and we believe we can persuade any impartial tribunal that the State Immunity Act does not apply to affect the taking of the assets. I'll close by referring to a controversy which has arisen in the legal scholarship in recent months on some of these questions. There have been a lot of important contributions by legal scholars over the last 6 months on these very questions. And the body of scholarship grows by the week. Just today, I was given by Philip Zelikow, a member of our panel, a copy of a memorandum he and other international scholars have published on the subject. I'll quickly say just this, Ambassador.
I'm running out of time.
There are some who say that the money, the Russian state assets can be seized,
Yep.
but not spent. They must be held, or they can be held, and used as leverage to persuade Russia eventually to pay compensation. I don't agree with that. I think that they can be spent, but there are some scholars who argue that the assets can be seized and held in escrow as leverage to influence Russia's response in any ultimate negotiations on the payment of reparations. I flagged that as an issue. It's still live. There are differing views on the subject, but I believe that the position for which we argue can be maintained. Thanks, Ambassador.
Dear panelists, so I just want to make sure that I give at least at a minimum everyone an opportunity to speak. So I was hoping to be a little bit more of a dialogue. But with that, I'll turn it to Senator Omidvar, who also worked for years with groups across Canada, including migration, diversity, and inclusion. And I was hoping you could describe your experience engaging with Canadian society and how it has informed the work in the area.
Thank you very much, and thank you so much to the Massey College and to the Raoul Wallenberg Center for organizing this important discussion. I've taken away a great deal, including an idea to bring some of the proposals to action, particularly the one calling for a resolution from parliaments in Canada to bring the children back. Perhaps there is a senator in the room who can act on that as well. So I have, the best way of answering the question is that the work of an independent senator who proposes a private bill, and I have proposed 2 private bills, both of them arising out of the wisdom and thought leadership of the World Refugee and Migration Council, of which I too am a member, with Allan, Lloyd, Axworthy, and more recently with Rob Currie. I have tabled 2 pieces of legislation, one which was adopted by Minister Freeland in a budget bill, and the second which is under debate. And this second one will enable Canada to cast its eyes on the bigger prize of state assets, because that's where the big money lies. In truth, we don't really know how much Russian state money is still in Canada, but the principle of the action applies. It's not whether it's $1 billion or 16 billion or less than $1 billion. It is that Canada sets a legal precedent that can be followed by other jurisdictions. And as we have seen with the forfeiture of oligarch assets, Canada was the first out of the lead to do that. It has been followed by other jurisdictions, most recently by Estonia, which is considering similar legislation. Sanctions, colleagues, I think we all know, work best when they're not done by one nation state, but when they are coordinated and amplified over other like-minded partners. In reaching out to the Canadian public, as you asked me, I commissioned a poll with my colleague, Senator Donna Dasko, who is a senator of Ukrainian heritage, and asked the people of Canada about their support for seizing Russian and Iranian state assets. The answer was quite unequivocal. 80% of Canadians who responded were in support of seizing Russian state assets, and 78% were in support of seizing Iranian state assets. What does this tell us? I think it tells us that Canadians are fairly on the side of justice and fairness, and they support the actions of the Canadian government. And that is signified by the fact that in Canada, at least, there is no political disagreement at this point about our support for Ukraine. I'm in Ottawa all the time, and I can tell you that rarely do politicians agree with one another, but there seems to be a consensus that we need to help Ukraine survive as a democracy in the interest of the global world order and eventually in our own self-interest. I think we know that. We have more than 1.5 million Canadians of Ukrainian heritage who live in Canada. They are very well organized. They're politically powerful. They know how the system works. And that, too, has helped a great deal to strengthen this political consensus. And I know your time is short, so I will make one last comment, and that is around the many arguments that we will hear today and hopefully soon in other places as well, about why we should or we should not seize and forfeit and repurpose state assets. The arguments are lined up on all sides. There was an article in the Washington Post, for example. And I will just say this as someone who is a legislator. We can hear all the arguments in the world, and there is no, there will be no complete consensus between international lawyers. Sorry, if I mean any disrespect. I work with constitutional lawyers who do not agree with each other. So I know that lawyers will always find ways of disagreeing with each other, as will international experts. What does this come down to? It comes down to a question of political will. And I believe that Canada has already demonstrated the strength of its political will by being the first out of the gate on sanctions on individuals, and I know that they have an aspiration to lead on this file. President Zelensky, when he was in Ottawa, in his remarks in the House of Commons, remarked that Canada is a bright light, and he asked us to shine a little brighter, and I think that shored up our commitment to take political action, which is necessary now.
Thank you very much. So with that, I'll turn it to Professor Currie, an expert on transnational crime. And in your view, what are some of the international legal dimensions of compensations, including the doctrine of countermeasures and its application?
Well, I think in the interest of time, I'll just hit the countermeasures point I'll sketch out the legal argument for it. Allan has referred to it, so has Senator Omidvar. The idea behind countermeasures is when a state is breaching an international law obligation that's owed to, let's say, Canada, then Canada can breach another rule of international law, possibly several, as a means of pressuring the offending state to stop it, to cease the breach. So here, Russia, as we know, has breached the obligation not to wage aggressive war against other states. Now, Ukraine is the victim state here. Canada was not invaded, but the rule of international law that Russia has broken is what's called an erga omnes obligation, meaning it's owed to every state in the world alongside Ukraine. So therefore, Canada is an affected state and has the ability to claim countermeasures. Now, the countermeasure, again, would amount to Canada somehow breaking international law as a way of pressuring Russia to cease its own breaches. There are requirements. There are always requirements. There are legal requirements around notification. There's a measure of proportionality that has to be imposed. Canada's best bet and the international effort that Canada is both leading in and participating in is the idea of suspending the immunity that attaches to Russian state-owned assets, as Allan referred to a moment ago. So once that's done, and there are various ways that it can be done, and in fact, Senator Omidvar's new proposed legislation is designed to figure out a good way for Canada to do it. But once it's done on the international plane, then the Russian state assets would no longer be immune, and Canada and other states would be free not only to freeze as we had, but to seize and to repurpose those assets. There are various ways domestically that it can be done, and the constitutional and international lawyers, I think, are arguing about it as we speak. Countermeasures have to be reversible. That's an important requirement. So maybe that takes simple forfeiture off the table. Take the assets, sell them, send the money to Ukraine. At least as regards property, once it's gone, it's gone. The best course then for Canada and for other states is not simple forfeiture, but is to seize the assets and transfer them to something like an escrow account. The idea being that this property will be used for the rebuilding of Ukraine to deal with those costs that the Deputy Minister spoke about earlier. The international compensation mechanism that has been discussed a number of times today. It has to have money sitting there. So Canada has got a role to play in this proposal, which is gaining steam internationally. There's work to be done. Like-minded states are assembling the legal machinery that needs to be done. But I want to pick right up where Allan left off, in a sense, and say that there is contention among the players, among the international legal scholars, among the politicians in the world about not just the workability of this plan, but even its legality. There's a lot of space to explore. There's a lot of room to disagree. And, you know, the best way I can come up with to phrase what's going on is to invoke a joke that our honored colleague, Payam Akhavan, told me years ago. He was explaining his legal colleagues a great practical plan that he had made in one of his great works of advocacy. And they said to him, yes, Payam, it works in practice, but does it work in theory? And I think that's really relevant here because we need to avoid the triumph of theory over practice. International law is a tool to be used in a principled way within a rules-based international order. But at some point, it must be the like-minded states that come together and say, we are going to move the markers down the field. We are going to shift customary international law, which is amenable to being shifted and ultimately accomplish these important goals that we've got here today. So the law does not need to stand in the way. The law can be utilized and purposed to accomplish these important goals.
Thank you very much. So Professor Zelikow, who I think is still on the line, wrote in March 2023 in the Washington Post that using Russian central bank assets that were frozen at the full-scale invasion would show Putin he cannot outlast Ukraine and its supporters. Just wondering if you wanted to speak to that, or has maybe your thinking evolved in terms of Russia perhaps exploiting the exiting of the international legal framework to its advantage? Over to you.
Well, I think the great issue of our time is this. We're facing the largest international aggression in our lifetime. In our lifetime. The largest international aggression since before the creation of the United Nations. So here we are nearly 2 years into the war, and we're still debating whether the Russian money left in law-abiding states can help save Ukraine's life. The situation in Ukraine is actually quite grave. Ukraine is under incredible strain. We're providing emergency budget support that keeps the Ukrainian government afloat right at the moment at a level of billions per month. There are enormous needs for huge programs of reconstruction and recovery. And then there's the further issue of all the kinds of claims that Minister Mudra was referring to at the beginning of the discussion. Russia is waging a war of attrition. Russia is planning for a long war, at least into 2025. And it believes that if it can't conquer Ukraine, it will wreck it, that the economy and the society will implode, and then that will have a lot of effects on Ukraine's politics. And here we are years in. We've frozen hundreds of billions of dollars and euros in Russian assets that they complacently, overconfidently left in law-abiding states, a circumstance that has never happened before in the history of the world. And here we are 2 years in, that money lying inert and useless, with no one having any plausible theory about how it ever goes back to Russia. And yet we're still debating whether and how we can put it to work to save Ukraine's life before it implodes. So if I can, I think that that's a refreshing way of trying to understand the stakes right now. That here we are with this situation, with this potential, with this war chest, game-changing war chest, literally in our hands, 2 years into the greatest act of international aggression of our lifetimes, deciding whether to use it. So I can get into more details, if you like, about the law, about where this stands in all the relevant governments, where the action is right now. But I think the overarching point for the audience is, and takeaway from this is, we need to get on with this now. And we need to get on with this at the speed of relevance.
Thank you very much for that. So I'm going to turn to Mr. Axworthy now, who will speak to sort of the geopolitical considerations of the issue. But I'm wondering, do you feel that the asset forfeiture will help dissuade Russia from continuing its war on Ukraine?
Well, I think let me just follow for a moment on what Philip just talked about in terms of the immediacy and the urgency of coming to a decision and implementing it, not within years or even months, but as soon as possible. Because the act of aggression is also being accompanied by a series of other elements and situations, which is weakening the support for Ukraine, and as a result, providing even more ambition for the Russians and for the other ilk of people around the world, the Iranians and the, I guess now the Argentinians and the Slovaks and the Hungarians, who really want to see the Russians succeed. Clearly, one of the biggest factors is the outbreak of the conflict in the Middle East. It has taken attention away, resources away, military supplies away, and increasingly it provides a counter measure of a political kind to what Ukraine's been counting on for the past 2 years. So there's now an alternative, and one that has a very strong demand. It also has created, as we know, a really kind of increased opposition to the support of Ukraine internationally. So many governments in the south of the world and others are basically saying that there's a hypocrisy at work in terms of responding to aggressions and responding to children's needs and responding to civilian attacks, and that you now have two parties, Hamas and increasingly the Israeli government, which are not abiding by international rules. And therefore, if we are being so staunch about the Russian aggression, why aren't we being a little bit more effective in implementing measures that have to be taken where there is all kinds of major use of force and violation against civilians who are the most vulnerable? And that means that the political sands are shifting geopolitically. We also have to look, and maybe Mr. Zelikow would speak further, but the tide is shifting in the United States around support. You've got a presidential election in a year. You have an absolute madman looking to become one of the alternative presidents for the Republican Party, who each day becomes more fascistic and more demonic in his clear identification with the authoritarians of this world. To think that the kind of support, which I think is the United States supplies something like 20 to 25% of the operating budget of the Ukraine government right now. Other countries have to try to make that up, but right now there's a huge gap. And the idea that there may be some breakthrough in the stalemates and the madness that's going on in Washington doesn't give us one a lot of hope. And therefore you need an alternative. You need to look at other issues. And I would think, and the minister who spoke first could provide more commentary, but people I talk to is that it's beginning to affect the morale of Ukrainians. They still are unified in their opposition to Russia, but the idea of continuing to watch slaughter of their sons and fathers and even daughters is becoming a telling sign. And I think Ukraine needs a booster shot. It needs to see something change that demonstrates that it's not going to be just same old, same old. And because right now, again, a blunt assessment is that while the West has been supplying particularly military materials and some degree of economic assistance, it's not been nearly enough to give Ukraine any kind of advantage in overcoming the Russian weight of people and population and just sheer indifference of its leadership to casualties and to destruction. So we're really facing, I guess, what you call a crossroads, an inflection point, a turning road. And I think that it does require action. And I agree with all those previous who said, yes, it's important to look at the legalities and the rules and the norms, but you have to decide what do you weigh, put more in the scales. The necessity of trying to find the right venues, I think Allan and Mr. Currie have laid out options in that area against the idea that if there's a faltering of the Ukrainian ability to offset the Russian aggression, then we're all going to pay a very huge price. And I think the effort by Canada to start with the leadership and the legislation is a beginning, but I think we're beginning to slow down. I mean, I hear now that we're waiting to see the outcomes of the court cases in Abramovich and the Russian airplane before we take further action. I mean, to me, that is a classic case of dancing on the head of a pin. And I think that if this meeting today has any message, it's saying that let's get with it. And I think I agree that Canada has an important role to play, not so much in the size of the assets that can be released, but certainly in the leadership and the effort to pry open and to provide innovative answers, to deal with the legal barriers, to make sure that what we can do in innovating and providing a new set of norms and standards and actions internationally, that's something we know how to do. We've done it in the past. And if time ever calls for it, there's an old saying about somebody commenting on a preacher one day who said he talks so much about what's right, he forget what's good. And now I think that we have to put it in clear perspective what's right, but we also have to understand that the good is going to be ensuring that Ukraine is able to offset and hope and win its battle with the Russians and not give them the satisfaction of knowing that they can simply use the weight of their population and the density of their morality to overcome. And that has implications for all of us and for the future. And I happen to be one of those who thinks that you have no time to waste when you plant a tree. You have to put the seed in the ground now. And this is the time to do it.
I'm just looking at the organizers. Do I have time to open a question? Okay, so I promised I would open up the floor to a question. Are there any questions from the audience or online? Please, go ahead. I think if you could use the microphone so that the online guests can hear too.
Unfortunately, that last speaker made me feel quite depressed. My name is Lisa Shimko. I'm chair of the Peterson Literary Fund. My question may be somewhat indirect. You've spoken about what we're doing in the West and the G7 and NATO-friendly countries, but I worry that the more we debate, Russia gets its signals ahead of time, and by the time we make legislative decisions, they've already got an alternate plan. And I'm wondering about your assessment about what our leverage is like, if any, in terms of countries such as the UAE and others where we've seen so much Russian money flood, and we see their banks now setting up special units because they can't keep up with the flow of Russian assets into countries such as the UAE. What do we do about those nations that don't want to play on our team, so to speak? How do we impose any leverage on them? Thank you.
Who would like to take that question? Okay, please, Senator.
I don't know how to put this on. There. Thank you for that question. I've been thinking about that too, because no matter the debate about sanctions and whether or not we will get to the objective of repurposing state assets, what is also true is that the Russian economy is flourishing as it's never done before, and it's partly because their oil has found a market. Now, we can't do anything about Russia selling its oil, but perhaps we can do something about those who buy the oil, which is where I come to. Perhaps, this group and others could put their minds together about what tools do we have in our toolbox to deal with states that are buying cheaper oil from Russia, flourishing as a result, and we are actively engaged in trading with them, working with them. I just wonder, that's an interesting question you've raised. I don't have an answer, but I have a glimmer of an idea, which is likely completely unknowable.
Moderator, may I just offer a footnote on that? I think, again, part of political reality is having enough support to do the things that have to be done. And I think we are losing that battle. This is not something the G7 can do by itself. I think we need to find ways in which we are able to begin to engage a number of other countries in the same fundamental mission to ensure that Russian aggression does not win the day. And we are losing that battle right now. And therefore, I think one of the options of looking at this repossessing idea, it does provide a tool by which other countries who have suffered under, let's take the Venezuelan example. There are a number of countries in the Americas who are paying a huge price because of the Venezuelan autocracy. And I think being able to attach resources from them would provide a signal. In other words, we can say there's part of a new toolbox internationally that can be used, by example, right now in Russia, that can be applied in other cases to provide accountability and to provide some enforcement of international rules. And that is maybe even sometimes the heaviest sledgehammer that repurposing can ultimately do in terms of helping to offset the kinds of movements that we now have in which brutality is becoming the order of the day.
Can I just add one word to say?
Ambassador, can I make a brief comment on this?
Without saying that the UAE isn't important, my mind drifts more to Belgium than it does to the United Arab Emirates, because it is said that Belgium is the largest repository of Russian state assets in the Western world. And I think the European Union has been slow and divided. They don't seem to have a common position on this. I think a country like Canada, having adopted the legislation we have, especially if we adopt the amendment proposed by the senator, I think there's a role for Canada in advocating in the European Union among all of its members that they follow our lead, that they take this action, that we respond to any questions or concerns they have about legal implications or implications for the international financial order, and that we engage in a level of promotion that will bring those countries around to our side. I think we start with the European Union, and then we can worry about the Middle East and the UAE, but that's where I would start.
Well, thank you very much, one, for sharing some very thoughtful and clear mechanisms and ideas on how to take this forward. So thank you for participating today, and I will leave it there.
I think Philip Zelikow had a point he wanted to make.
Sorry?
That's all right. That's all
Oh,
right.
I'm sorry. I got the sign. Are we? Can we give him a minute? 1 minute,
it's
please.
okay.
No. Please go ahead, please.
Well, just to be very brief, you don't need the UAE, you don't need to cut off Russian oil. The Russian assets we're talking about are in the G7 countries, including 5 members of the European Union. Only 5 out of the 27 countries actually have these assets. Sanctions against Russia are a difficult thing to do. If you look at where Russia sells its oil, its number 1 client is India. The notion of trying to cut off oil shipments to India is a big hill to climb. So put that hill to one side. We can do hundreds of billions for Ukraine without talking to the UAE or talking to India or doing anything about further sanctions on Russia. This is money that is already in our hands. All we have to do is mobilize it and put it to work. And then that's just a series of legal and policy problems for which people are getting the answer.
Right, thank you.
Thank you, Ambassador Cmoc and our distinguished panelists. We now have reached the final part of today's program. And I would ask the Prosecutor General, Andriy Kostin, to share some concluding remarks, after which I will also share some concluding remarks. Please.
Dear all, dear friends of Ukraine, true leadership in time of war means bravery. Bravery is not a theory, it is always the action. And while Ukrainian soldiers display the bravery on the battlefield, some of us fight on the legal front, using all legal mechanisms on national and international level in order not only to restore justice, but to secure just peace, in line with internationally recognized values and principles. There is no fear among Ukrainians. Primary victims, but also survivors of the aggressive war and horrendous crimes, only determination to fight till victory for our freedom while holding Russia responsible. I believe today's panel discussions demonstrated that there is no alternative. We must pursue justice on multiple fronts through the intrinsic web of accountability by, first, investigating and prosecuting international crimes on national level in Ukraine and before the international tribunals, International Criminal Court. Second, continue to utilize international law in order to reach planners and designers of the crime of aggression, the masterminds of this evil architecture via establishment of the Special Tribunal for the Crime of Aggression and the work undertaken by the International Center for the Prosecution of the Crime of Aggression in The Hague. And three, to ensure reparation of harm to victims and survivors, as well as Ukrainian state by setting up international compensation mechanism and by pursuing vigorously sanctions regime. And most importantly, as rightfully noted by the honorary citizen of Canada, respectful Nelson Mandela, we owe our children, the most vulnerable citizens in our society, a life free of violence and fear. Therefore, we must act before it becomes even harder. We must act before it becomes too late, as history will remain the witness of our response towards unpardonable atrocities. Thank you.
Dear friends and colleagues, this brings us to the conclusion of the program. And I just thought I would share with you a few words in conclusion. We've had an extraordinary day for which I must thank the Office of the Prosecutor General, my dear friend Andriy Kostin, Ambassador Kovalev from the Embassy in Ottawa, the Government of Canada, and of course, Massey College, which has hosted us, and the Raoul Wallenberg Center for Human Rights, especially to Elissa Ginsberg and Kimberly Lenz for all their hard work. We have heard a lot today upon which we can reflect. We began with a discussion on punitive justice, restorative justice, rehabilitation of traumatized children. But perhaps one aspect which stuck with me more than anything is that while the pursuit of justice requires a long-term commitment, time is of the essence for the liberation of the thousands of children who remain in the Russian Federation's custody, who've been abducted. And as we heard, for a small child, a year is a very long time. So we have to fight on two fronts. One is to ensure that the mechanisms for justice can function over the long term, while doing our utmost to send the message that it is unacceptable in the 21st century to abduct tens of thousands of children and then to forcibly assimilate them into a culture that is not their own. We heard from 11-year-old Ilya from Mariupol in the video that we saw this morning. We heard from 16-year-old Vladislav from Melitopol, and there are many, many other stories. There are the words of Ivan, a child who says, "Before the war, I was a child with many dreams. Now I have a scar that will never disappear. My childhood was claimed by war." We can never forget the scene on February 24th of this year, on the one-year anniversary of Russia's war of aggression, when there was a patriotic rally in Luzhinsky Stadium outside of Moscow with President Putin, and children whose parents were killed in Mariupol by Russia's own acts of aggression and inhumanity, being paraded in front of a soldier who was presented to them as Uncle Yuri, who had liberated them. And I need not say how grotesque this Orwellian propaganda is. It's very easy to despair and say nothing can be done, but the first step is speaking truth to power and saying with a unified voice that this is entirely unacceptable, that the civilized world will not accept such atrocities to be committed. I'm very pleased that the Honourable Foreign Minister Mélanie Joly expressed Canada's indication of support for a network, or as Andriy explained, a mechanism which will systematically, rather than on an ad hoc basis, work at the international level for the liberation of these children. So having said all that, I want to thank all of you for having come today and for having supported this cause. And hopefully this will be the third in an ongoing series of United for Justice conferences, the fifth one, because there is still a long road ahead. So thank you very much once again, and all the best.